Um, so, uh, so uh, Today's first speaker is Professor Ken Sato from the National Institute of Informatics, Japan. Professor Ken Sato is a professor from National Institute of Informatics in Japan. He has been studying logical foundations of artificial intelligence for 30 years and published more than 150 papers. Currently, he is interested in applications of logical framework to law, such as a support system for judges and a compliance mechanism of AI. In preparation for this research topic, he entered the law school of the University of Tokyo in 2009 and passed the Japanese bar exam in 2017. So that's really interesting that he also studied in law school. And his talk today is interactive system for arranging issues based on PROLEG in civil litigation. So they have been developing this PROLEG language or system to simulate judgment reasoning after all the relevant facts are determined. So before handing over to Professor Sato, I just want to mention some things. So for the part, first of all, for Professor Sato, so the talk will be for about 45 minutes approximately, and then maybe 10 to 15 minutes for question and answers. And for the participants, you cannot directly ask questions. So please use the Q&A function here. You can see at the end there is a Q&A button. So use the Q&A button to ask your questions. And at the end, maybe Professor Sato or me can read those Q&A questions, and then Professor Sato will answer them one by one. And if you have any problems or any general questions, you can use the chat window to ask that. So for example, if you are finding any audio or video problems, you can ask this in the chat button. But for asking question, please use only the Q&A function. Okay. So now I request Professor Sato to give his talk.
Thank you very much for the kind introduction. I would like to share my screen. Wait a minute. Yes, this one. Can you hear? Can you see? Is this right? Okay.
Yes, I can see it.
So today I would like to talk about the interactive system for arranging issues based on PROLEG. So firstly, I would like to give my introduction, and then I would like to talk about our main activity in National Institute of Informatics on AI and law called Juris Informatics. And then I would like to explain about our development of PROLEG, which is PROLEG-based legal reasoning support system. And then I would like to talk about the extension of this PROLEG for interactive system for arranging issues. Okay. So firstly, I would like to talk about my introduction. And I think that the most of the things have already been introduced. So I have been working on logical foundation of AI and incomplete information called non-monotonic reasoning. And to seek the application of my work, I entered the law school in University of Tokyo and learned law in 2006 and 2009. So at that time, I was just like 58 or something like that. And among the young students, I learned law there. And during learning at the law school, I found that the theory of judgment in civil litigation called the ultimate fact theory taught in the law school is closely related with my work. Because this ultimate fact theory is a kind of theory which handles uncertainty in real life for litigation. And my ultimate goal of non-monotonic reasoning is the same as the ultimate fact theory. So I immediately understand the relationship. So I developed a programming language called PROLEG, prologue-based legal reasoning support system, based on the above idea, aimed at assisting law students and lawyers. And I also started the workshop on Informatics, from 2007. And as a byproduct of the research, I passed the bar exam in Japan in 2017. I also started the workshop on the, not workshop, but competition on CORI, which is competition on legal information extraction and entailment from 2014 as well. This was mentioned in the last line. But anyway, I developed a language called PROLEG to simulate judgment in civil litigation, and I have been a steering committee member of the workshop on Informatics. And we will have Juris 2022 in June 2022. And also we set up a competition on this domain in 2014. And this year we will have CORI 2022 co-located with Juris 2022 in June. Okay, I would like to talk about PROLEG-based reasoning, legal reasoning support system. So firstly, I would like to talk about reasoning step in civil court litigation and which part is supported by PROLEG. And then I would like to talk about the Japanese presuppose ultimate fact theory. And then I give some flavor of PROLEG program. So there are 3 steps in civil court litigation. One is the fact-finding phase. Second is subsumption phase. And finally, it is judgment phase. And in fact-finding phase, a judge decides the truth value of facts in the considered case. So facts should be contribute to judgment using evidence. And evidence itself is also a fact. So we need to decide the truth value of evidence as well. And we need evidential reasoning as well as reasoning from basic facts. And note that the truth value might be undefined. In legal terminology, it is sometimes called non-liquid because of the lack of the enough evidence to decide the truth value of certain fact. So for example, suppose a judge would like to decide whether there was an agreement about purchase of goods or not. So the fact is the agreement about purchase of goods. And I would like to know the truth value of this agreement, the existence of this agreement. And if a plaintiff gave some basic facts, such as email exchanges, which can derive the fact of agreement, a judge will take into account of this base fact to decide whether there was an agreement. But there is some possibility that this email exchange might be fake. So the evidence itself has a kind of truth value, which is fake or not. And in substantial phase, a judge makes correspondence between specific facts and legal concepts. So specific facts is actually in real life facts, and in legal concepts, it is in the legal domain, and we need to find out the correspondence between specific facts and legal concepts. And the truth value of specific facts is reflected to the truth value of concrete legal concepts. For example, suppose a judge decides the truth value of agreement for the purchase of goods is true. Then this agreement corresponds with establishment of contract in a legal term. So the truth value of established contract is true in this case. If the purchase of goods is undefined, agreement for the purchase of goods is undefined, then the establishment contract also is undefined. So it is three-valued. And in judgment phase, according to the truth value, a judge decides which legal rights or obligation exists. However, the truth value is three-valued, so some judgment could become undefined in a deductive logic. And in this case, a judge cannot make a deductively correct decision. However, in litigation, a judge cannot allow to give a judgment of I don't know, and is forced to make a decision. So how should I do? How does a judge do with this kind of situation? So to solve this undefined situation, the Japanese presupposed ultimate facts theory is invented. So basically that even if there are not enough evidence about deciding the facts, we need to find out the way of the determination of truth value. So Japanese presupposed ultimate facts theory called Yoken Gijitsuron in Japanese, and JAF theory for short in this presentation has become mainly developed by judges in Japanese Legal Training Institute. And this is an interpretation of civil law from the judge's view in order to handle the uncertainty in the court because of the lack of enough evidence. And unfortunately, this theory had not been attracted by university scholars in law department in Japan for years, but thanks to the Japanese judicial system reform, this theory started to be taught in law schools, and the interest in this theory has grown. So it happened in 2008. And from that year, the ultimate fact theory becomes somehow popular. And when I entered law school and I learned this theory, it surprised me very much that judges made such a rigorous framework without knowing mathematical formalization. I mean that nomotonic reasoning is a kind of a mathematical formalization of handling uncertainties and how to get some kind of a satisfactory answer. And the purpose of this JAF theory is also same as this kind of thing. So we propose a representation of legal knowledge which is more friendly of JAF theory to lawyers, which is called PROLEG. And actually that in the first place, we use ordinary logic programming language called PROLEG to express JAF theory. But with discussion with lawyers, they basically don't understand the reasoning step about the PROLEG, especially for the negations failure, nested negations failure. And so we decided to change the syntax so that we can talk about general rules and exceptions in PROLEG system. So first, I would talk about JAF theory. JAF theory is a theory of determination of conclusion used by judges under incomplete information. After both parties finish their activities in the proceedings, in other words, it is used for judgment phase. And JAF theory divides conditions of legal rules into two categories. One is for a plaintiff, somehow preferable for plaintiff, and the other is for a defendant. So each party has a burden proof for this kind of preferable facts. And
Sorry, we can't hear you, Professor Sato. I think you are on
Sato,
mute.
you have got muted, it seems, by mistake.
sorry, so I'm sorry about that.
Yeah, it's okay. The last 10-20 seconds we missed, so maybe.
Oh, really?
Yeah.
Oh, I
Yes,
didn't know.
yes. I
Why?
think you are on
Not
mute.
much.
Just wait a minute, I have to check. How can I do that?
No, I think you are. I think last part I heard is like the JUF theory is a theory of determination of conclusion. So that's
Maybe
what
you
it
could
added.
start from the beginning of this slide. That would be fine.
Okay.
Yes.
So JUF theory is a theory of determination of conclusion used by judges under incomplete information after both parties finish their activities in the proceedings. So in other words, it is used for judgment phase. And JUF theory divides conditions of legal rules into two categories. And one is for plaintiff, preferable for plaintiff. And the plaintiff has the burden of persuasion to judges for this part. And the other is for a defendant. And that part, for that part, defendant has a burden of proof. And actually, the JUF theory is a theory of judgment. And can you hear me?
Yes, I can hear you.
JUF theory is not the theory of argumentation, but both parties should obey the JUF theory. Otherwise, they will lose. And that activity is really similar to the argumentation. But the ultimate purpose of this JUF theory is judgment used by judges. And both parties should simulate judges' reasoning to make a preferable conclusion for each party. And so our claim is that the activities at court are not argumentation, but persuasion activities towards judges, at least in Japan. Okay. So we implement the JUF theory by using logic programming technology, and we call the system a PROLEG-based legal reasoning support system. But it's not commercially available, but an experimental system still. Also, okay. And so PROLEG system consists of rule-based and fact-based. And PROLEG rule-based consists of the following expressions. And so two categories. One is a general rule, and the other is exception. A general rule of the form of home clauses without negations failure, and the form is H, left-hand side, left arrow, and B1 to Bn. And the meaning of this rule, general rule, is that if B1 to Bn are true, H is true in general. It doesn't mean that if B1, Bn are true, H is always true. It doesn't mean that, but H is true in general, because there is a possibility of exception. And an exception is an expression of the form exception HE, where HE are atoms, each of which is a head of rule. And the meaning is that even if there is a rule which satisfies the condition of rule for H, if it is true, H is false. So if exception E is true, then even if all the conditions for general rule is true, conclusion will be false. And another syntax is called PROLEG fact base, consists of the truth value of basic facts of the form, like fact B. This means that the basic fact P is true. Okay, this is an example of PROLEG rule base. So this means that the first rule says that the purchase contract is established if purchase contract agreement happens. And there is an exception that is purchase for purchase contract establishment. And the exception is rescinding contract due to duress. And this rescinding contract due to duress also has a rule that has three conditions: duress action, feeling fear, manifestation of recession. If these conditions are satisfied, then the exception is true. So even if there is an agreement of contract, purchase contract establishment becomes false. And
so, Professor Sato, I have a question.
Yes.
I need a clarification. Can you please go to the previous slide? Yeah. So in this case, you said this. So H so is implied by B1, B2, Bn, and
Yes.
but there can be exceptions. Now suppose so there is one rule H, this implication B1, B2, Bn, and there is another rule exception He. Suppose both all B1, B2, Bn all are true, as well as this E is also true. So is it that exceptions will always override the general rule?
Yeah, that's right. Even if there are two rules for general rule with the same head, if E is true, then all the two rules will be invalidated.
Okay.
And actually, we can have some kind of program technique for the for validating specific rule among multiple rules. Actually, it is just to introduce another predicate for H, that H if H1, H if H2, and so on. And H1 has the first, the body of the rule. And if we write exception H1E, then that is the exception for the first rule and so on. So that kind of programming technique can be used for exception for some specific rules among multiple rules. Okay.
Okay.
So then the fact base is like this form, so that there is some kind of instantiation variables. So Alice, Bob, contract one, and so on. So this means that there is a purchase contract agreement between Alice and Bob with contract one, and there is a duress action of Alice to Bob about establishing contract by duress, and so on. And actually, we have reasoning simulation, and we can show the simulation results by block diagram. And this is called PROLEG block diagram. And the left hand uppermost box is the ultimate conclusion. And in this case, it is U. U is undefined. Undefined というか、undefined. I think that this is for block diagram for arranging issues, so it can be undefined, but in civil litigation, we cannot have undefined, but true or false. And it is because that fact it has some undefined value. In this case, duress action and feeling fear is undefined. You know that the bottom part of the box expresses truth value. And so in this case, the solid line from the left hand uppermost box expresses one rule, which is the head and body. And so purchase contract establishment and purchase contract agreement here is another rule. And this dotted line shows the exception of this rule. And so in this case, if this is true, then even if this part is the body of the conclusion is true, this becomes false. So that kind of thing can be represented in PROLEG diagram, so that we can understand the reasoning process about judgment. And the current status of PROLEG project is as follows. So implementing the full job theory in PROLEG about contract law, and we have implemented more than 2,500 rules in civil law and Supreme Court cases by Todai Law School graduates, which is the best law school in Japan. And also we are working on the answering yes/no question of Japanese bar exams. And we are working on solving yes/no questions by a combination of natural language processing and PROLEG to solve subsumption problem and provide a correct explanation why the statement is correct or incorrect. But still it is ongoing work, and we are now working on translating natural language description of case into PROLEG fact base. And if we have a PROLEG fact base, then the PROLEG rule base is already implemented so that we can get the judgment. That is current status. Okay. So it is the end of the presentation about the PROLEG itself. If you have any questions, then you can ask now.
So if anyone has questions, particularly from the participants, so they can use the Q&A button to ask the questions, and panelists can directly ask the questions if they have.
How do you see these questions? It's automatically popped up.
So you can look at on your screen at the bottom, kind of right, there is a Q&A written there. So you can click on that Q&A and you will be able to see those questions.
But in that case, I have to stop the sharing?
No. You have to go to the Zoom window. So I think currently you are in your PowerPoint, right?
Yeah.
So you have to go back to your Zoom window and then there you have to look for the Q&A. Otherwise, if you are not seeing, that's
Maybe,
okay.
Yeah. Okay.
Yeah, so that's a like odd feature of Zoom, that when you put the PowerPoint or the PDF and then you don't see that, you only see the small thing. So it is different in like WebEx or Teams. So, but in this case, yeah, you can see at the end. But I don't see any questions. So you can
I will
continue.
Proceed.
Yes.
Thank you. And sorry. So I would like to talk about the extension of PROLEG, which is an interactive system for arranging issues. And I would like to firstly give a background and extension PROLEG to arranging issues. And then I give some demonstrations and I conclude my talk. So background is that we need a computation support to arranging issues in civil litigation. And in Japan, we have the procedure of arranging issues in civil litigation where we clarify which facts are in dispute and what kind of evidence action should be made. And so this is very classical procedure. And in every civil litigation, that kind of procedure exists because we have to see the evidence and then finding out the judgment. And in the beginning of 2020, the Japanese court decided to use Microsoft Teams for arranging issues. And they said that they would start the procedure from May 2020. And due to the COVID-19, this system has been intensively used in Japan. But however, the usage of Microsoft Teams is just to replace face-to-face procedure by the one in distributed environment. So it's not a real extension of or real usage of IT technology to enhance Japanese court activity. So they apply IT technology to the procedure in a very superficial way and doesn't make the full use of IT technology. So in this presentation, we extend the PROLEG into an interactive system for arranging issues, which is important procedure in civil litigation. So here is an example of claims in civil litigation, and we use this example for demonstration. So there is plaintiff Alice and the defendant Bob, and Alice claims as follows. I ran door-to-door sales of water purifiers. And on January 15th, 2020, when I visited Bob's home and explained about water purifier, and Bob said that he would like to buy it. So I made a contract. So she made a contract with Bob and delivered the water purifier. However, Bob didn't pay the price. And Bob has claimed that the water purifier was a contract made by Menace and was invalid by cancellation. But Alice said that there is no such fact, but maybe Bob doesn't like it, and he would like to return the goods. And on the other hand, the defendant, Bob, claims that Alice visited my house on January 15th, 2020, and asked me to buy a water purifier. And he refused it. However, she shouted, "If you don't buy it, I'll visit you every day until you buy it." And he was scared and said, "I will buy a water purifier." And the water purifier was delivered, but he said to Alice that I will cancel the contract for the water purifier. And however, Alice said that I have already delivered it and will not accept returns. Please pay the price, otherwise I will sue you. And she sued me, and I'm very embarrassed and so on. So there are some irrelevant facts in litigation. The important part is, so we need to identify, firstly, which fact is related with this problem, this case, to win. So that part is very important. If the either party doesn't give a correct claim, then the judge immediately reject or accept the claim. So therefore, we need to be careful about to give necessary and sufficient conditions for win the case. So it is necessary to extract the legal facts from the above claims to form an appropriate argument in the court. And if any side doesn't make a claim in a legal correct manner, the side will lose the case in the trial. However, the above claims contain various facts, and it is not so clear which of them should be selected. And PROLEG can choose requirement facts automatically by reasoning about PROLEG rules, because PROLEG rules is a kind of rules for judgment, and the base facts in base conditions in PROLEG expresses necessary facts, and therefore, if we ask these necessary facts to the user, then the user should extract the information from the natural the description written in natural language, as the previous example. So it is somehow helps the lawyers to understand the situation, and also maybe the amateur people as well. So to handle this, we need an extension project to arrange issues, and that is indexing a level for PROLEG results. Firstly, we define the dependency on the atomic formula that appears in the general rules, and then the first among the conclusions of the rule, the conclusion that doesn't appear in the body of the rule of any general or in the exception of any exception rule is called zero level conclusion. Then finally, we making a top-down proof tree from the zero level conclusion using only the general rules, we end up with the fact predicates, and we call the fact predicate finally visited zero level facts and the zero level conclusion, and the interactive visit atomic formula calls zero level atomic formulas. So basically that this is, we assume that there is no exception, and try to find out which fact is needed to get a conclusion. And suppose that I-level atomic formulas and the I-level facts are decided. Then we consider about the exception. And for exception rules that concludes with the I-level atomic formula, the collection of the atomic formula of the exception of the such exception rules are called I+1 level exception. So if there is an exception, then the level is incremented by 1, and so on. So somehow this is a pictorial explanation about using block diagrams. So basically that this is a conclusion, then only the general rules we can find out conclusion, then these used facts is called zero level facts. And then we consider about the exceptions, and if the formula is used only in the first the first exception, then it is called one level atomic formula. And then the exception, we consider about the exception and exceptions, and it is called two level atomic formula, and so on. So in the block diagrams, we can put all the we can put the labels for each node, which expresses the condition. And let's plaintiff choose one of the following zero level conclusion. Then this is the plaintiff's claim. Then we make a top-down proof tree of zero level conclusion. When we encounter the zero level fact, we ask the plaintiff if the plaintiff claims a fact. And if the plaintiff claims it, then we let the plaintiff to instantiate variables in zero level facts and add it instantiated facts to the fact base. And you reflect the relevant part of the proof tree with such instantiation. So basically that this zero level formula, it contains only variables, so that the user must instantiate variables for the entities in their case. And so if the plaintiff claims it, then we let the plaintiff to instantiate variables. And if the plaintiff doesn't claim it, we delete the path related with the fact in the proof tree, because in this case, we don't care about such a kind of non-claim, unclaimed, unstated claims. And if all the concrete facts are entered, the modified proof tree is displayed, and it is iteratively done to get the appropriate variable instantiation. And if all the concrete facts are entered, the modified proof tree is displayed and continue above until there are no arguments raised from either side. So for example, the level facts are claimed by plaintiff, and then there is first level atomic formula claimed by defendant. Then the exception of exception is claimed by plaintiff. And this formula has ultimately reached to some fact. And if the fact is encountered, the system will ask the variable instantiation. Okay, I would like to show you some demonstration using the water purifier case. Okay, can you see the demo?
Yes,
so
you can see.
So that, okay, so there is a menu. So firstly, what do you want to do? And then there is some options of what you would like to do. And in this case, Alice wants to request money payment. Alice is, in this case, plaintiff. So this one is chosen. And then we have three options to get such a kind of requesting money payment. And so in this case, purchase contract. So we choose the first one. Then the PROLEG program computes which rules is applied and which facts are needed. So this is what we have now. So requesting money based on purchase contract is true if purchase contract establishment is true and if purchase contract agreement is true. And so this box, left-hand box is the final goal. And the currently value is U. U is undefined. And then we have to put instantiation for each items. So in this case, actually, this is Alice. And this is Bob. And the contract one. This means that between Alice and Bob, there is a person, there has been established purchase contract agreement according to contract one. And we also change. Q is somehow a prompt for a system asking instantiation. And so we have done already. So we put O, which is true. Okay, so then all the values are instantiated. And then using PROLEG system, we can simulate the judgment. So we can run this. So in this case, the previously the value of the top goal is U, it becomes O, and the other part is O. So this means that according to this facts, the Alice will win. But there is exception of exceptions, and actually a PROLEG system can automatically reason about such exceptions. So the green box expresses that they have some exceptions. So we check it. And in this case, the descending contract due to duress is closely related. So we would like to not claim, but give a facts for this fact box. And then the fact, base fact is 3 conditions here. And we need to edit this. So this part is contract one, contract name, and then O, contract O. This part is O. This part is O. So all the facts are entered. So we apply this to the block diagram. So in this case, this exceptions is added here. And we don't claim about this part, so we just leave it. Then we simulate this block diagram so that the unstated claim will be disappear. And we only have the facts related with this part. And then in this case, the plaintiff will be loose. So we would like to have some exceptions. Or, so in this case, it fails. And or we have to change the value of the facts into undefined. So for example, Alice said that she didn't menace Bob. So in this case, we say that it is undefined. And also the second one is also. This is all. So, although now, so we simulate. No, sorry. We should deny the fact. So I'm sorry. So this part is undefined, and feeling fear is also undefined. Sorry. So plaintiff doesn't admit these facts. So this value becomes undefined. Then simulation is occurring. And then in this case, the conclusion becomes U, which is that we don't know the current situation because we need to find out the issues which has a value of undefined here. So if this part is determined, then we can get some results here. Okay. And so this is so in this case, the issues are all the fact box which with undefined value. So these values, this undefined box is related to the issues, so that we don't care about this part because the both parties admit and so on. Okay, so I go back to the slide here. So conclusion is that extension PROLEG to arranging issues is that attorneys can prevent missing claims by using this system for checking, and layperson could make a correct legal claims. And I would like to make a version of the system which is used by some laypersons, and whether he or she can extract the necessary facts or not. And another one is automatic information extraction from claims written in natural language. So instead of asking a user which value is for which variables, but if we can automatically extract the claims from natural language sentence, then it would be better. So we are making research on this. Okay, so a conclusion on judicial informatics, and I found that there are many opportunities to apply informatics AI techniques to legal reasoning besides the above work, which have not been explored because of the academic gaps between informatics, AI field, and law. And in general, there are much unwritten implicit knowledge which do not appear in textbook in other domains, and it is possible to acquire this knowledge only if we enter the field deeply. And so in this case, in my case, I entered law school to understand the problem deeply. And I wish that more people would be interested in this domain. This is an interesting domain for AI, which needs combination of symbolic computation, legal reasoning, and also neural computing, legal document processing. Okay, that's all my presentation. Thank you very much.
Thank you, Professor Sato, for an illuminating and very interesting talk. Now, I would request if participants or panelists, any of them has any questions, so participants can use the Q&A button to ask the questions, and panelists can directly ask the questions. So please ask your questions. We have about 15 minutes. Yeah, Shobik, you raised hand. Can you, if you are interested to ask question, can you ask it?
Yes, thank you, Professor Sato, for this very wonderful presentation. And as a person purely from the legal domain, I'm slightly curious about something. When your system is able to look into or arrange the competing claims from the plaintiff and the defendant separately, is there any way to consider that when these two claims are actually presented before a court of law, the court is obviously going to look into the evidence and figure out which claim is a better one or which claim is more accurate, factually accurate, etc. So is there any scenario wherein the system can actually, based on these two layers of competing claims, the system will also be able to make any kind of prediction that probably this claim is not supposed to be this does not have a proper correlation with the factual evidence or whatever we have. Is that possible at this point of time?
The first is that my system is based on my rules are based on civil court or Supreme Court cases. So they are all relevant. And to win the case, we need to satisfy all the conditions in the rule. So even if in the judgment phase, at least, if you claim irrelevant, if you make irrelevant claim for these rules, then you immediately lose the case. So you have to be careful about to make correct statement related with the condition of rules. So in this case, you know that even if the plaintiff or defendant gives various facts, but if it is not matched with the conditions, then they will immediately lose. That is one part. And but in judgment phase, for example, in evidential fact-finding phase, for example, in this case, the judgment is not judgment is somehow probabilistically. I mean that in evidence, some evidence is weak and some evidence are strong. So in this case, we cannot use logical reasoning because usually logical reasoning doesn't have such a kind of strength of the conditions. And so maybe currently we are collaborating with Bayesian network people, and they calculate about possible probability about which fact is true or not. And using this kind of Bayesian network, I think that at least which fact evidence is weak and which evidence is strong, so that we can make some kind of separate distinguishment or comparison between the plaintiff's evidence and also defendant's evidence. Is that okay?
Thank you.
So I don't see any other question in the Q&A. So I have a question. So so in this system, that is so that PROLEG language, right? So you have a set of so logical clauses, and then based on that you are doing arguments, right? Now my question is that suppose you reach to a logical conclusion, right? So maybe say the plaintiff's argument is true or the defendant's argument is true. Now in a courtroom, when a judge gives a decision, he or she also gives elaborate reasoning for why he or she came up with that decision, right? So you have to just not give your judgment, but you have to give them the facts and the maybe the thought process, or not maybe the thought process, but at least what are the evidence for and against that thing. So for your PROLEG system, so do you output any of the, like, suppose you reach a logical conclusion, so what are the supporting facts for coming up with such a decision? So do you output that also, so that otherwise there will always be doubts in the minds of the particular losing party, right? So they may question that. How do you convince them that your system is correct?
So there is some there are various kinds of definition of correctness in the system. And for example, if suppose that we have a correct rule reflected from the civil court and Supreme Court case, then the correctness is related with the judgment correctness. So so in that case, the meta interpreter of rule handling doesn't work very well, then the answer becomes incorrect. So that is one possible correctness, definition of correctness. The other one is that there is also a possibility of introducing errors about the translation of the civil code and Supreme Court cases described in natural language. So we need to translate this natural language into predicates. So sometimes some arguments in the PROLEG predicate might be lost, so that if we use the correct, even if we use correct meta interpreter, the judgment will be incorrect. That is another possibility of incorrectness. And also that if you enter the incorrect fact, then also the incorrect conclusion will be made. So such a kind of possibility of introducing incorrectness exists, and I think that especially for how to translate natural language description into logical formula is very important, and also very difficult to validate that the translation is true. So basically, all we can do is that for the checking of the rule, we apply these rules for various problems and whether the desired conclusion is obtained or not. And if the entrance of the facts is wrong, then the conclusion becomes wrong. Then we have some kind of legal debugging facility whether which fact is incorrectly inserted. So that system is also developed. Okay.
And how do you, for example, decides which are the, so in case of a conflicting clauses. So for example, let me give an example. So in a logically consistent systems, so if there are multiple clauses, they should not contradict each other. For example, if there is a statement is, so there should not be another statement not is, right? So both of them cannot coexist. Now, suppose let us take an example. So there is an implication rule, say A implies B. Now A could be like Bob. Bob wanted to buy that water purifier or that machine, right? So Alice is claiming Bob wanted to buy the water purifier, which is say S, and Bob claims that Bob did not want to buy that water purifier, which is not S, right? And based on that, there may be an implication system that maybe S implies B. Now these two different people, their so-called fact or claim is directly contradicting each other, right? Now in your, not only in your system, for that matter, any logical system, you cannot put both of them together to make some conclusion, and there will be several conflicting claims, right? So for example, if it is a case between public prosecutor and the defense attorney, prosecutors will, the state will claim something and the defendant will come in. So in many cases there will be this kind of S and not S, right? So how will you resolve those things, because you have no prior knowledge about whether the prosecutor, what prosecutor is saying, that is the fact, or the defense attorney saying that is the fact, right? So how do you resolve those kind of things?
So basically, that the PROLEG system doesn't have such contradiction, because we just use civil code and Supreme Court cases, and this actually doesn't have any contradiction. I mean that we resolve the contradicting results by introducing exceptions. You know that if we have A, if B, and so if B is true, then A is true. But if we have B and the exception C, then it becomes not A. But if we consider about A if B still, then the B is still true, so that the A is true. But if we consider more about the exception C, then it becomes not A. So seemingly it is a contradiction. But actually that because we have a priority of the exceptions, so that such a kind of contradictory conclusion will be obtained from PROLEG system. So basically, what the Supreme Court case rules doing is that if there is some kind of ambiguous or contradictory conclusion in the civil court case, and then the Supreme Court decide which one is which conclusion should be taken. So basically, that the Supreme Court Supreme Court gives preference over the always preference over which condition is true, so that such a kind of contradictory conclusion will not emerge in my PROLEG system. So basically, this is predefined.
And these exceptions, so you have, I think you initially mentioned there is a general rule and there is an exception. So for example, some of these exceptions, are these determined manually by the domain expert who is designing this PROLEG system, or this can be automatically figured out by the algorithm?
This is manually, totally manual. And so I believe that, for example, civil code is quite stable code, a law, so that once you make such a kind of rules, then you can use maybe for 20 years or so. So we decided not to get automatically extraction of logical rules from the natural language description, but the expert construct rules manually. Okay. But actually that, you know, new law comes and it, for example, tax law is frequently changed over years. You know, every year the tax rule is changed. So in that case, we may have to have some kind of support system of automatically change for the such kind of frequently changed law. But at least as far as civil code is concerned, it is very stable, so that manual construction is sufficient. That is my opinion. Okay.
So are there any other questions? I don't see any questions in the Q&A box. So if no one has any questions, so let's thank the speaker. Of course, we cannot clap on this virtual environment, but
thank you.
I mean, it was really an entertaining and very illuminative talk. So we understood some of the issues in this court systems and the reasoning about that, and how so Professor Sato made a very ambitious and nice attempt to formalize these systems and argue about that and try to give an automatic solution. Now we have this Professor Sato. I think you also got this. This is for a private session with the panelists and the organizers. So the link is given to. I think you must have seen the link here and on the chat window. So
yes.
Please click on this, and then you will get out of this Zoom room, and then you will get into that room. So I'm clicking on that. So you also you and all of the panelists, I request them to click on this link and go to that room. Okay. So thank you and see you there soon.
Thank you very much.